that the path that Congress had given him was not one he wanted to follow.
Let's talk a little about bail. I mean, we have a bunch of findings from this district judge that this Khalil does not pose a risk of flight. He's not a danger to the community. Shouldn't that ultimately be dispositive? You didn't oppose that, so.
I don't believe so, Your Honor, and I think it has a fundamental defect. Certainly flight risk could be a valid component of the bail analysis, but in order to have that sort of interim, equitable relief, he needed to show a likelihood of success on the merits.
Bail is not equitable, by the way. The way the district court entered the preliminary injunction, that was equitable, but bail itself is a legal remedy that doesn't depend on likelihood of success on the merits.
Well, this court in Londano said that it did. It read the test as being a conjunctive test that required both likely success on the merits as well as extraordinary circumstances.
All right, let's talk about Professor Kellen Funk's brief, which suggests that if anything, the district court applied too stringent a bail standard, and that historically for people who haven't been adjudicated guilty or anything, the standard should be just reasonably required to assure the person's appearance.
Well, Your Honor, certainly those are more typically criminal concepts.
Okay, but he's not charged with the crime here. It suggests that he should have a lesser standard rather than a greater one.
Well, Your Honor, certainly bail is available before the IJ, and so all of this is being conducted in an improper form as an initial matter, and so I think that that should be a full stop. I think this court's decision in Londano also suggests that likelihood of success is an important part of the analysis. In fact, a necessary component of it, and so between that and this does seem like interim relief to us. And I think
Londano and Lucas are both post-conviction habeas cases. After conviction, the liberty interest is less. About the chance you're going to get your conviction overturned.
Your Honor, we're already pretty deep into the criminal context, which I don't think there are apples to apples comparisons. And I think that the principle that Londano recognizes is an important one. That the idea that you could get a release order where a district court thought there was only a 1% chance that you would ultimately succeed on the merits, strikes us as very odd. And I think, even if you think Winter isn't directly controlling, it is the sort of informs the correct analysis. What the district court here, Lucas as well recognizes this as an extraordinary remedy, much as injunctive relief is an extraordinary remedy. The idea that would issue in a completely merits agnostic way is something that is just, it seems like a very foreign concept. And it seems like this court in Londano thought, that needed to be a component of the analysis. And we think the district court abused its discretion and committed legal error by not analyzing that component.
Thank you. We'll hear you back on rebuttal, Mr. Ensign.
Thank you, Your Honors.
Mr. Kaufman.
Thank you, Your Honor. I'll be addressing the jurisdictional questions, and my colleague, Mr. Hodgson, will address the preliminary injunction and the merits of the bail order. The core of this case has been undisputed for 6 months. People in our government didn't like the protected pro-Palestine speech of a lawful permanent resident, so they detained him, sent him far away to Louisiana, and began efforts to remove him from the country while proudly warning others that they might be next. Across the law, First Amendment injuries are seen as special, and the nature of the extraordinary harms from ongoing government censorship in this case means that finding jurisdiction here would be consistent with the INA. Immediate habeas review is necessary not only because the freedoms the First Amendment protects are so foundational to our democracy and to the remainder of our rights, but because every day of delay simply furthers the unlawful retaliatory ends that Mr. Khalil is asking the court to stop. The district court properly understood this in finding jurisdiction and granting preliminary relief, and this court should affirm the injunction as well as the bail order.
What's your response to the government's argument that the judge in New York knew that your client was in Louisiana? So why wasn't the petition transferred to Louisiana?
Well, I think the question before the New York court was where the petition should be transferred. And 1631, which the government has not addressed the text of that statute at all in this entire litigation, makes very clear that can go to, if the Padilla rules apply, it can go to the district of confinement, and that's where the district of confinement was. And any other rule would run right into endo.
It wasn't the district of confinement at the time of the transfer. It was the district of confinement at the time the petition was filed in New York.
That's right. But that's exactly why.
Why, help us figure out why it's better to say that the transfer should occur to the place where I think every reasonable person would agree it could have and should have been filed in New Jersey. Obviously, you would have filed in New Jersey had you known he was in New Jersey, right?
Of course.
But why is it better for us to create a rule that the transfer should occur to the place where the filing could have happened rather than the jurisdiction where everyone knows the petitioner to be located?
Well, I think we're not asking you to create that rule. Congress created that rule. It wrote the statute to say that you can transfer if finding in the interest of justice, which the district court did. It actually requires transfer to the place that it could have been brought, which is New Jersey. That's the district of confinement. And no one argues that had the petition been brought in New Jersey at the same time, there wouldn't have been habeas jurisdiction there. Of course there would have been. And the statute is also clear that the petition after transfer is treated as if it was filed at the original time. And that takes care of all these kinds of concerns. You know, the government's effort to transfer this case to Louisiana is completely atextual. There's no basis for the idea that at that moment, there could have even been a filing in Louisiana when he was confined in New Jersey. I don't even understand that.
There'd have to be a new filing.
I think that's it. You know, the government, you know, has sort of gone back and forth throughout this litigation of whether petitions should be dismissed, whether it be transferred. In the Southern District of New York, which is the transfer we're talking about, the government said, yep, you can dismiss or transfer maybe to New Jersey, and maybe we'll contest it there, maybe to Louisiana. It never provided a basis for the Louisiana transfer at all. And I think sort of that tactic of sort of complaining about jurisdiction wherever you move to is exactly what the court in ISIL was talking about when it said that can become a Kafkaesque experience where the government is chasing you around to different jurisdictions and telling you don't have habeas jurisdiction. So I just think that's not at all on the table. I think the government's arguments on habeas are weak and dangerous. They don't engage with the text of the statute. They don't engage with the text of 2242, which explicitly says that if your custodian is not known, it does not need to be named in the petition at all. And so there's an argument that the petition, even without naming the custodian at all, was properly filed. So I really think the government's overreading a lot. It overreads the language in Padilla about endo only applying if there's a proper filing. I think Section 1631 very clearly makes clear that is treated as if it was filed. That's the entire point of the 1631.
Let's talk about the scope of habeas. You'd agree that habeas fundamentally is about detention, correct?
The core of habeas is always understood to be detention, yes.
Okay, and JGG seems to expand that a little bit. What's your view about how far JGG expands that?
Well, I think there's a little debate about JGG. I think you could read it to say that it covers removal claims that are inevitably follow from detention claims. But I think the important point for us is that either JGG controls and there is habeas jurisdiction over all the relief that was granted here, or we have 1331.
Well, there's a middle ground, right? Isn't it possible that there's habeas jurisdiction over some of it, but not everything? I mean, the June 11th order was quite different from the July 17th order. And you seem to sort of quickly allied the notion that while I appreciate your agreement that habeas is fundamentally about detention, you sort of quickly then said, well, it's about removal too. And that's a large leap, right? How do you get from detention to removal? And what precedent do you have to support that?
Well, I think the starting point would be the court in St. Cyr talking about how there's always been habeas review over some aspects of removal. And so I think that shows with JGG that there is the ability of federal courts to review some elements of removal and habeas, especially as JGG suggests when those things are identical.
But St. Cyr preceded the statute at issue, though. Isn't that a problem?
Are we talking about the INA now?
Yeah.
Well, I don't think so. I don't think
the INA, it was an overhaul. Isn't it fair to say that this was a complete overhaul by Congress? This airlifted all these cases from the district courts, and it set up a fairly reticulated scheme that said the way it's going to go henceforth is you're going to go in front of an immigration judge. And if you don't like what the immigration judge does, then you go to the Board of Immigration Appeals. If you don't like that, you go to the Circuit Court of Appeals and then to the Supreme Court. That's the scheme that Congress set up, correct?
Yeah, that's true, Your Honor, but I think that is sort of taking the INA bars question into the relief question. And I don't think that's really necessary because, again, we have 1331. And another way to explain what happened in those later orders, the court issued an injunction against detention and removal. And then the rest of it, he was enforcing that PI, So there was an effort in his equitable authority to sort of enforce his own orders to add more to it because the government essentially ignored the preliminary injunction from the start. But I do think that regardless of whether there's habeas jurisdiction over that kind of relief, there would be 1331 jurisdiction if the INA doesn't strip it. And we don't think it does. And so I think that's sort of
go to the INA.
Okay.
So 1252B9, I mean, it says consolidation of questions for judicial review. The Supreme Court has referred to it as a zipper clause. And the logic of EOHC is you get one chance to remove things. So if there's a claim you're not going to be able to review at the end, we'll review it now. Conditions of confinement, medical treatment, maybe length of detention. But I thought the strongest point the government made was the constitutional challenges made here, challenging detention, are identical to the ones being made for removal. So if, I know you're contesting whether the removal challenges have to be hived off and go to Louisiana, but if they do, doesn't that mean that likewise these detention challenges, you'll get a chance to review them there, the underlying claim? Isn't that what you get one shot at versus your theory is it's hey, there's a harm we're suffering now. Why should we read 1252B9 and EOHC your way rather than the government's way?
Well, first, I think as it relates to detention, and I think this court was clear in EOHC that the entire arising from interpretation from Jennings is about relief. And Jennings is very clear. Detention claims just simply do not fit into that construct.
I think there's language in EOHC that cuts both ways. The introduction says, ordinarily, you've got to wait. But then there's a special situation when you won't be able to review the claim later. Now, there are other places in the EOHC that talk about the harm you're suffering in the meantime. But this case is on a fault line or a knife edge of an issue that EOHC didn't have to confront because both the claim and the harm would be unremediable later. Now, the government's stress is, hey, you will get a fair shot at this void for vagueness claim down there. If it's right that claim and challenge to removal has to wait, why shouldn't the challenge to detention likewise? You'll get that legal issue resolved then. Why not wait? Because the B9 says consolidation of questions for judicial review.
Well, I think neither of them has to wait for different reasons, but similar reasons. The detention claim doesn't have to wait because, as Judge Freeman was explaining earlier, the detention claim, you can't remediate detention pending an adjudication if it's unlawful at the end of that proceeding. And that follows from EOHC, from Jennings, and from multiple Supreme Court cases after that. So I think detention clearly cannot be remedied. But what's unique here in this case is the harms that are flowing from this unique provision and it's the application by the Secretary of State. And that brings this case much closer to EOHC and the now or never analysis, and firmly within it, actually, because these are harms that also cannot be addressed at the end of the process of a PFR. And the EOHC opinion is very illustrative in coming up with examples of kinds of claims that would work. So one was if your claim is that you're being
Yay. That's right. Changing world it is. Well, our numbers are a little bit old at this point. Certainly, we took a look at the race in September. At that point, that was still with Mayor Adams in the race, although we asked every single respondent the contingency planning, if you will. So clearly, we had Assemblyman Zoran Mondani way ahead at that point in a four-way race, up by over 20 points. But when we asked, should Eric Adams drop out of the race, and we found that the vast majority of Adams voters, about 77%, said that they actually would migrate over and vote for Andrew Cuomo rather than Zoran Mondani. So the race clearly in our polling was earmarked to tighten up with Adams dropping out of the race. The current polling of some of our colleagues continues to show Mondani with about a 10 to 12 point lead. But at this point, with Curtis Sliwa still in the race, it doesn't appear that polling indicates that Cuomo has closed the gap. Now, in New York City, the big question always is turnout, turnout, turnout. In a typical mayoral election, about 1/3 of registered voters in New York City turn out. So right now, we're looking at who's going to motivate the soft New York City voter to show up. Is it going to be Mondani or is it going to be Cuomo? And that question is the one that's going to end up deciding the election in a couple weeks. Sure. I mean, it is indeed difficult. The first challenge is, of course, getting people to respond to us. So, whereas in the golden age of polling, everyone had a landline, we called them up on landlines, they all answered and they spoke to us. That day, of course, is gone. So we're primarily using cell phones, and we're also augmenting cell phones with text to web. So typically, we're texting people, we're identifying themselves, we're giving them an opportunity to respond via the web. If they don't respond via the web, then we call them on their cell phone. Tremendous issue with non-response bias. To give you a little bit of insight, we probably will make in an average hour, one of our interviewers will dial the phone as many as 60 times. Of those 60 times, about 15 people will say hello. Of those 15 people that say hello, 1 or 2 will take the survey. Now you add to that we want to have a representative sample. So we have quotas in this case, whether it be by borough, by party registration, by age. So it is indeed very challenging to get a representative sample of the electorate. You add to this non-response bias, this question of who's actually a likely voter. Every pollster has their own recipe to determine likely voters. The old method was simply you ask people, how likely is it that you're going to vote on election day? What we do now is we compute the probability that someone's going to vote based on their prior vote history. We call off the list of registered voters, and then to that we add their stated probability when we speak to them on the phone. We merge those two together as a score, if you will, and then we apply that to their answers. Absolutely. There's a tremendous amount of statistical work in the background, both in terms of generating the sample, putting quotas in place as to who it is we actually speak to, And then after we've collected the data to apply these statistical weights that includes the likely to vote, as well as weighting by the probable makeup of the electorate. It's always a challenge in an election. If you think about it, we're asked to poll and generalize to a universe of people that exists at a point in the future. And clearly, we've got to build a model of what that electorate looks like. We primarily do that based on historic turnout. But in a race like this, where we anticipate a greater than average turnout amongst younger voters, new voters, voters who have not previously demonstrated a record to vote, then we alter our model to reflect the likely electorate on election day. Well, I understand that. It is a task that we engage in that is both art and science. I think that what you want to look at is really the average of all polls, honest polls who transparently go out there and seek to contribute to our democracy by giving voice to the electorate. Clearly, it's easier if you ask me to poll New York City and to determine attitudes towards trash collection. It's something that affects every single New Yorker. I could probably nail that right to the number. This is more difficult because not only do I have to get the right voters, but I have to compute their likelihood to vote. So it is a daunting task. And I think that voters should take a look at it and take it for what it is, an attempt at a point in time to measure the probable opinion of the electorate. Still, every voter should make up their mind and go out and vote regardless of what my poll or anybody else's poll says. Well, I think they're different. The problem that President Trump has created over the past number of years is what we call the non-response bias. We have measured and shown that overall, that ardent Trump voters are simply a little bit less likely to participate in polls, in part because of the president's view of fake news and that polling is part of what he believes to be a liberal bias. Entirely different situation with Mamdani. There, we're looking to poll voters who have historically not been part of the election process. They don't have a voting history to some extent. Younger voters who historically, there's always been a lot of tailwinds, people saying, okay, the young voters are really motivated this time. They're really going to turn out. Think Cynthia Nixon, for example, when that election expected a tidal wave of young voters. So different reasons, different challenges. These are things that pollsters are aware of. We make every best effort to include, whether it, when polling President Trump, those voters who are less likely to participate because of their ideology, or in this case, New York City, making a decided effort to reach out to young voters, voters of color, voters who have not historically been involved in the process. Not easy, but we're doing our best every day. Levee, drove my Chevy to the levee. Director, Siena Research Institute. All right, we got an interesting one. This is not for tape, but we're going to come out later this week. Just for fun, we did a poll on kindness amongst New Yorkers. So, what do people feel as though, yeah, so that'll be out later this week. All right, thanks a lot. Yep, bye-bye.